Thus says the Lord, set your house in order, for you shall die and not live. Law Bob Radio. Law Bob Radio. Welcome to Law Bob Radio with your host, San Jose estate planning attorney Bob Bergman. Law Bob Radio. Bob has been practicing law for over 30 years and is certified by the State Bar of California as a legal specialist in estate planning, trust, and probate law. Bob is here to help you set your house in order with valuable insights you can use today to prepare a better tomorrow for your loved ones. And now, your host for Law Bob Radio, attorney Bob Bergman.
Hi, welcome to Law Bob Radio with your host, estate planning attorney Bob Bergman. We've been covering a lot of territory in the first two parts of this three-part series on ways you can mess up your estate plan. What I want to do is encourage you to visit my website at lawbob.com, that's LEWBOB.com, or lawbobradio.com, that's all one word. You can find out information about my legal services as an attorney, find out about living trust seminars that I have coming up, and generally get a lot of useful information that you can download and read. You can also view my living trust seminar online. There's links to go to YouTube and actually watch that if you can't come into a live seminar. So please feel free to give me a call or contact me with your messages at rbb@lawbob.com. I think you'll find I'm very easy to deal with and very accessible. So we're going to cover in this last part the last several ways that you can mess up your estate plan. And this next one is a really big one, and I've seen some serious mistakes made over the last number of years, pretty much by people doing self-help planning. And this has to do with disinheriting a child. Now, some parents have children that they've decided for whatever reason should not receive anything from their estate when they die. Sometimes that includes children that may have been born years ago in a relationship that was not intended, what are called generally illegitimate children. I don't like the term illegitimate children. I think all children are legitimate. All children are brought to us from God, and no one's illegitimate at all. Let's just say that maybe the parents of that child, they're the ones that engaged in an illegitimate relationship, and the child is the result. However, sometimes people will decide they don't want that child to actually receive anything. Now, there's a man named Ken. His will left his estate to his two children, but his will never mentioned Ken's child by a prior marriage, and Ken had not seen this child for many, many years. Although you can disinherit children by specific reference in your estate planning documents, because there was no reference to Ken's first child in his will, and I would include, if he had a trust, the same thing, that first child may be entitled to a portion of Ken's estate under state law. This child would be what's called a pretermitted heir. That's a legal term of art, and it means someone who is your natural heir that's known about that you failed to mention in your estate plan. The law presumes if you failed to do that, it was a mistake, it was an oversight, someone drafted it incorrectly, they forgot to write little Johnny in, and that's why little Johnny should get an equal share of that estate. So if this disinherited child who's not mentioned contests the will or a trust, the other children may be forced to settle for a significant portion of the estate to avoid tying up the estate for years in litigation. Some people will leave a disinherited child $1. Now that action at least shows an acknowledgement of the child and intent not to leave any substantial inheritance. However, I feel if you're going to do this, it's better to acknowledge the child's existence and then state something like, for reasons personal to me, I've not left my son Johnny anything in this will or in this trust. Now, I sometimes advise clients, especially if they have substantial estates, it might be better to leave enough money or property to the disinherited child to discourage them from filing some form of contest of the will or trust. See, the deal is this. You can have what's called a no contest provision in a will or a trust, what we call an in terrorem clause. It's intended to intimidate that heir so that they will not go to court and fight about things. Well, if you disinherited someone completely, they have nothing to lose in the fight. But if they go to court and they lose, then that no contest clause might be used to mean they get nothing. So it might mean you leave that child $50,000, and now they have to think, if I go and fight to try to get more and I don't win, if I can't prove that mom or dad was mentally incompetent when they signed that, if I can't prove that my other siblings used undue influence or one of the other reasons you can attack a will or a trust, then I'm going to end up losing the $50,000 they left to me. So a lot of disinherited heirs will think twice before they go to court and argue about it. So that's why I recommend using a living trust. You can also have fewer notice requirements when someone dies if you have a living trust, rather than if you have a will and you have to go through the probate process. Now, another mistake that's very, very subtle is someone missing a deadline to exercise a disclaimer. Now, what's a disclaimer? That is a refusal to accept an inheritance. For example, if I was left $50,000 by my father and I didn't want the $50,000, I wanted it to pass on to my children, I could say in writing, under state law, one that complies with IRS regulations as well, that I don't want to receive that money. And as long as I do that within 9 months of the death of my father, and I do it correctly, that will act to mean that I don't receive that money. Why would you want to disclaim? Well, let's say that a couple has a taxable estate and they have a lot of joint tenancy property. One spouse dies, and if the other spouse disclaims the deceased spouse's half, well, then that spouse's half will pass to their children, or if they had things in a living trust, it might pass to the bypass trust for the benefit of the surviving spouse. So if you have a qualified disclaimer, that means that it's qualified under the law. The disclaimer is not treated as a taxable gift from the person who did the disclaimer. So qualified disclaimers are an important planning tool in many estates. In fact, some estate plans are designed to anticipate disclaimers being used to save on estate taxes, for example. Now, another problem is just relying on wills for estate tax planning. Some attorneys try to accomplish tax planning with complex wills. Often the planning fails because couples still hold title to their home and other assets in joint tenancy, or they've named each other as beneficiaries on life insurance and IRAs and other retirement plans. Thus, if you have all this elaborate planning in a will on the first death, basically nothing passes through the person's will, which means all the tax planning in that will is never used. Everything passes outright to the surviving spouse, which means that everything's included in the surviving spouse's taxable estate when they die. So, also, if you want to accomplish estate tax planning on the first death and you're using just wills as your estate plan, then both spouses will have to have probate when they die. Now, is it any wonder why will-based estate planning is typically recommended by attorneys who love to do probate? Attorneys make a lot of money in probate, so if that's what they're recommending, think twice. Is this really the proper approach? I think living trust planning makes a lot more sense. You can avoid probate on both deaths, and you can still achieve the desired tax planning results that you might want from your planning. Now, here's a serious one, and sadly, it's something that occurs fairly regularly in this country and in California especially, and that's not doing any kind of new estate plan while a divorce is pending. Now, if you get a divorce, under law, your ex-spouse with that divorce decree is disinherited from your will or trust and also removed as a beneficiary on various kinds of property you own. Removed from your 401k plan, your IRA, not removed, however, from your life insurance that you might have. Plus, if you still have a will or a trust together with them and you don't revoke that and do some new planning, and then you die while the divorce is still pending, you could end up with everything actually going according to that will or trust, which means it may end up going to your ex-spouse. You might have wanted to make sure that it goes to your children or to others in your family. That's why if you're facing divorce or contemplating filing for divorce, it's time to get together with somebody like me to talk about what options you have and whether or not you should do things like revoke a will or a trust and set up your own estate plan to protect yourself and your family. The last thing is the failure to have proper beneficiary designations on your IRA. Now, after his wife died, Fred was advised to name his 3 children as the beneficiaries on his IRA. Then, after he died, it was discovered he had never done that, and all he had done was name his now deceased wife as the beneficiary. Unfortunately, the IRA agreement stated that if there was no surviving beneficiary, the IRA will be paid to his estate. Although it means that his children will get the IRA through probate, they'd have to cash in all of the IRA in a very short time, perhaps only within 5 years, and they have to pay income taxes on everything they receive. Now, had Fred named his children on the IRA beneficiary form, they could have pulled the IRA as an inherited IRA and could have spread out the paying and the income tax liability over their respective lifetimes, with the inherited IRA continuing to grow on a tax-free, compounded basis until their deaths. Plus, Fred could have set up a special type of trust that could have provided asset protection for the IRAs for his children. We call that the IRA Inheritance Trust or Retirement Plan Trust. That's something I do in my practice, and feel free to contact me if you'd like to talk about that. So after the break, I'm going to be talking in the final segment about the last things that you can do to mess up your estate plan. So until after the break, this is Attorney Bob Bergman.
For questions or comments, send email to lawbobradio@gmail.com. That's lawbobradio@gmail.com. Now back to Law Bob Radio with your host, San Jose estate planning attorney Bob Bergman.
Hi, welcome back to Law Bob Radio with your host, Attorney Bob Bergman. I'm going to cover in this last segment of this 3rd-part series on ways you can mess up your estate plan a few more things, and we're going to do a little recap of what we've covered. Another thing that I see, and this is kind of an important one, a lot of people have large estates. A lot of people actually have people that they're caring for. Maybe you're sending several $100s a month to your elderly mother, or you're caring for your grandmother, grandfather, something like that. And people don't have in a power of attorney being a legal document that you can give to someone to handle things like investment decisions, filing tax returns, dealing with government agencies like the IRS, Franchise Tax Board, Medicare, Medi-Cal, Social Security, all those kinds of things. Failing to put in a power of attorney authority for your power of attorney agent to make gifts or to continue gifting money or caring for someone from your property. Now, here's an example right here. Harold was on his deathbed. His son knew that Harold had a taxable estate. That means federal estate tax. So his son, acting under a power of attorney, made gifts of $14,000 each year from Harold to himself and each of his 4 siblings and all of their spouses. So he basically made 10 $14,000 gifts, and that turned out to be $140,000 removed from Harold's taxable estate. Now, at a 40% tax rate, that would have saved, that's the current tax rate, that would have saved $56,000 in estate tax for the family. Unfortunately, the power of attorney that Harold's son used did not specifically grant the son the power to make gifts of any kind, which meant that the son actually exceeded his authority under state law and the IRS did not allow the gifts at all. They were deemed to be incomplete, and when Harold died, that $140,000 was brought back into his taxable estate, and the family lost $56,000 in federal estate tax. Now, a power of attorney generally does not give your agent, that's the person you name to act with authority to do the things in the power of attorney, doesn't generally give that agent the authority to just give away your property. The agent is supposed to operate in your best interests. And the problem is here that if Harold had the legal right to get those gifts back from his children and their spouses, then the IRS would actually include them in Harold's taxable estate. So by not having the gifting provisions in the power of attorney, as I indicated previously, the family ended up paying $56,000 more in estate tax. So the moral of this story is be sure that if you have a power of attorney and you want it to have specific gifting provisions, you want to make sure that that is actually put in your power of attorney. Something important to note here is that the California Form Statutory Power of Attorney, the one that the legislature created a number of years ago, that is freely available for download from the internet, does not include any gifting authority. You would have to add that in yourself, and you would also have to know what to say in order to make sure that that gifting authority actually went in there. And what I find is that people don't know what to say, and a lot of times they think that because they have a power of attorney, that means they can do anything and everything. Doesn't work that way. The power has to be specifically stated in the durable power of attorney. Now, another mistake is making the assumption that if you have a living trust, it's going to accomplish all the things and take care of all the problems, all the messes, if you will, that I've talked about in these 3 shows. And what I've seen is there are literally thousands, probably tens or maybe even hundreds of thousands of poorly drafted living trust estate plans, and for that matter, will-based estate plans that are drafted by paralegals, online services, document preparation services, self-help books, people just looking something up and throwing something together on their own, inexperienced attorneys who are selling trusts and wills without really being qualified to do so, and even some I've seen drafted by financial planners or accountants for that matter. Some living trusts I've seen will not even avoid probate. A trust like that would say something like, upon my death, my trust shall be paid to my estate. Well, your estate means your probate estate. Many trusts drafted for married couples don't have estate tax planning provisions or even have the ability to do estate tax planning through disclaimers and things like that if it was necessary. And I see trusts, and there's a really, really significant online service. I will not name them, but you hear their ads all the time. They don't even recognize that the couple lives in a community property state. And a community property state such as California has some special rules for step-up in basis for capital gains tax purposes and other issues that if a trust doesn't address the fact that it's a community property state, it can cause a lot of problems and confusion and even have provisions that are contrary to the laws of a community property state. The fact is, a living trust that's poorly drafted or incomplete is a broken trust. Now, I fix broken trusts. I'm the trust doctor. I go into court several times a year to fix trusts that were broken, trusts that were poorly drafted, trusts that don't say what the people thought it was supposed to say, trusts that actually say something directly contrary to what the couple actually communicated to the service or the attorney that drafted it for them. Families have to spend thousands of dollars going to the probate court in order to fix problems like this, and I'm happy to charge them thousands of dollars because it's not an insignificant problem if a trust is broken. The good news is, if you have a broken trust, we can fix it. If you're still both alive, or if you're alive and you're an individual, we can fix it before your family has to. If someone has already died, we can go to court and fix it as well. Now, another thing, there's no such thing as a simple living trust or a standard living trust. You could have a trust that's as short as 1 page long or one that's 150 pages long. I can tell you that the length of a trust does not determine the quality, and also who prepared the trust is probably a better indication of the quality than its length or any fancy language that's in there. Now, the last mistake, and probably the biggest mistake of all, way to mess up your estate plan, is to not have an estate plan at all. If you've done nothing, and you know what, you're in good company if that's the case, about 2/3 of the country don't do any planning at all, ever. If you don't have an estate plan, the state of California has drafted a plan for you. It's called the Laws of Intestate Succession. And I've mentioned this earlier. That's basically the laws that say who gets your stuff when you die if you didn't have a plan. And the people who would inherit from you probably going to be the people you'd want, but could end up being people that you would not want or would not even expect. Not many people would purposely let their state legislature draft their wills for them, but that's what you get when you don't plan yourself. As an example, if there's a lot of property titled just in the name of a deceased spouse, that property may end up being distributed 1/3 to 1/2 to a surviving spouse, and then the other 2/3 or half to the children. This is rarely what married couples want. They generally want to provide for each other first and then see the kids get an inheritance only after they're both gone. Many married couples erroneously assume that if one spouse dies, all property will automatically pass to the survivor. That can be wrong. California law may require that a significant portion pass to the deceased spouse's children or even his or her parents. At a minimum, you should at least have a will, and I really think you should have a properly drafted and funded living trust with powers of attorney and advanced health care directives to avoid a conservatorship if you become disabled, avoid probate on your death, and for married couples, and depending on the size of the estate, potentially save thousands or hundreds of thousands of dollars in federal estate taxes, rather than relying on a simple will or joint tenancy. So I'm going to wrap up today. The problems we've talked about, the mistakes, the messes you can have in estate planning are just a small sample of the mistakes that are frequently made. Many times I can make changes to estate plans to avoid these problems. Other times it's too late to solve the problem without going to court. I hope these examples of common mistakes have helped you to better appreciate just how complicated estate planning is and the role that an experienced estate planning professional can have in creating an estate plan for you. So please, if I have prompted you maybe to consider that now it's time to do planning, or maybe have the planning you've done reviewed to make sure it actually does what you want it to and it doesn't have problems in it, please give me a call at 408-247-0444. Visit my website at lawbob.com, or email me at rpb@lawbob.com. So until my next show,
you've been listening to Law Bob Radio with estate planning attorney Bob Bergman. Bob gives regular seminars on estate planning and is available to do estate planning presentations for churches and other community groups. For more information or to schedule a consultation, visit lawbob.com, lawbob.com, or call his office in San Jose, 408-247-0444. That's 408-247-0444.
Opinions expressed are for informational purposes only and should not be construed to be legal, financial, or tax advice. Seek appropriate legal advice regarding your particular situation. Attorney Bob Bergman does not offer any guarantees with regard to the outcome of your legal matter. Prior results in other cases do not guarantee a similar outcome in your case. All rights reserved.